Hello students, this is Ruchi Jain from Shivaji Rao Kadam Institute of Technology and Management. Friends, in the series of video lecture for the subject Business Law, our today's topic of discussion is Dissolution of Partnership Firm. Friends, according to section 39 of Indian Partnership Act, the dissolution of partnership between all the partners of a firm is called the dissolution of the firm. In case of dissolution of a firm, there is complete breakdown of the relationship between partners, between all the partners. On the other hand, dissolution of partnership involves only a change in the relationship of partners. For example, retirement of a partner, or we can say death of any partner from a partnership. So this does not say dissolution of firm. So there are some modes of dissolution of firm. Basically, there are two modes for dissolution of a firm. First one is dissolution without the order of the court, or dissolution without the court, or second is dissolution by court. First, we are talking about dissolution without the intervention of court or without the order of the court. This dissolution comes in Partnership Act from section 40 to section 43. First is by agreement. Dissolution by agreement. This was mentioned in section 40 of Indian Partnership Act. This dissolution says if a firm may be dissolved by the consent of all the partners and in accordance with the contract between them. A firm may be dissolved at any time with the consent of all the partners. This appeals of all cases where the firm is for a fixed period or at will. A firm may also be dissolved in accordance with the contract between the partners. The contract for the dissolution of the firm may be express or implied. It means if it says that in agreement it is mentioned that for a particular period of time partnership will dissolve, then it will. Second is compulsory dissolution. It was mentioned in section 41 of Indian Partnership Act. This compulsory dissolution is of two situations. First one is by the adjudication of all the partners or all partners but one as insolvent, because there must be at least two partners to constitute a firm. And if no partner is exist or only one partner is exist, then the partnership is compulsorily dissolved. The second condition is by the happening of any event which makes it unlawful for the business of the firm to be carried on and for the partners to carry it on in partnership. So in that case, this is compulsorily firm will be dissolved. Now the next is dissolution on the happening of contingent events. In section 42 this was mentioned. For example, there are subject to contract between the partner. A partnership is dissolved by expiry of the fixed period, the expiry of the term for which the firm was constituted, the completion of the particular adventure if the firm is constituted for the execution thereof, or we can say achievement of the task. For example, for a particular film ABC, the contract is created, the partnership firm is created, ABC film is completed, the contract is dissolved. Next is death of the partner. Next is insolvency of the partner, and last is resignation of the partner. These all are the cases by which firm will be dissolved. Now dissolution by notice. In section 43 this was mentioned. Partnership at will means the duration of the partnership is not fixed. In such cases, partnership may be dissolved at any time by any partner by given notice of his intention to dissolve it. Notice should be in writing and should be signed by the partner giving it. It should be served upon all the partners. In such a case, the firm is dissolved from the date mentioned in the notice. This is called dissolution by notice, and this notice is given by partners. Now, in continuation, the another second type of partnership dissolution is dissolution by court. Under section 44, the court may dissolve the firm on the following grounds if it's suited to field by the partner. First one is insanity of partners. If a partner has become of unsound mind, the court may dissolve the firm on the patience of any of the other partner or by the next friend of the insane partner. Next is incapacity of partner. If a partner other than the partner suing has become in any way the permanent incapable of performing his duty as a partner, then in that case the court may dissolve the firm. Next is misconduct of partner. Where a partner other than the partner suing in the guilt of misconduct, it is likely to affect the carrying on the business, the court may dissolve the firm. Next is constant breach of agreement by partners. If where a partner other than the partners suing persistently commits breach of the partnership agreement related to the management of the firm or conduct of the business, in this situation court may ask the partner to dissolve the firm. Next is transfer of interest. If a partner has transferred his interest in the firm to a third party, or where his share has been attached under or we can say it is sold in the recovery of arrears of land revenue, then in that case court may dissolve the firm. Next is continuous losses. If in such cases, if the business of the firm cannot carried on or expect at a loss, the court may dissolve the firm at the suit of a partner. The partnership firm is formed to earn and share the profit, and if continuously it earns loss, then in that case court may ask to dissolve the firm. Next is in any ground, like just an equitable, court may dissolve the firm in any ground, like if cooperation is not continuous, or it may be due to the disputes are maximally arise, something is not equitable, then in that grounds the court may ask for compulsorily dissolve the firm. So friends, thank you very much for this topic. Today our topic Indian Partnership Act 1932 is completed. Thank you very much.